And following right up, look, we have a caller. Somebody must be interested to talk to us. I'm going to take it.
Or it could be the person who we prearranged to call us.
Who would also be interested in talking with us.
Might
Correct?
be interested in talking to us.
Hello, welcome to the Cabbage Cafe. Who am I speaking with?
I might be interested in talking to you. This is Paul. How are you guys?
Paul Tylenda, attorney Paul Tylenda. How you doing?
Very well, thanks.
Paul, I'm so glad to hear that you're listening out of generosity, not because we're on the clock here, because I know what you charge. So, yeah, let's not do that.
It's after hours.
Isn't that double time?
Paul Tylenda's
True.
We talked about Paul a little bit in an earlier section of the show. Paul's a criminal defense attorney with a long history of defending patients in Michigan in a wide variety of communities. He's from the Grosse Pointe area and does a great job in Wayne County, but I've seen him stretch all the way up into, Port Huron areas. You've gone well beyond that, too, haven't you, Paul?
I was just coming out of St. Helena County this afternoon as we speak, actually. So
Exactly. So that's a real
fun.
Tough area, too, when you're talking about the I-94 drug corridor.
Some of the stuff's become kind of highly specialized, and Paul's in a relatively small group of lawyers who really know all the nuances and ins and outs of this whole thing.
it's becoming that way, yeah, which is kind of interesting. It's also become kind of terrifying, too, when you get someone who's just, I can handle this case, sure, and then next thing you know, you have to pay someone to clean it up. So.
A lot of people call themselves medical marijuana attorneys, and when we have a discussion and they haven't heard about a lot of basic things or what's happening in other courts around there, it becomes a little concerning.
Mm-hmm.
Yeah, I mean, it's
troubling there. Everybody's a medical marijuana lawyer these days.
If you let everybody claim to be a gynecologist that wanted to be a gynecologist, it probably would be a pretty gross situation. So, we should have some kind of...
It would be.
Yeah.
There should be some standards.
Right now, if that were the case.
Yeah, that's right.
I would not be a doctor.
So, Paul, one of the things we talked about earlier was the Agro case. And Jamie, of course, gave a little bit of a rundown and discussed the longevity of the case and its significance and how it's really being underplayed. But I think we wanted to explore that a little bit, right, Jamie?
Yeah, and I think maybe Nick and or some of the other Agro family members may be interested in the future and kind of discussing their perspective and their experience with the whole thing. And it includes, the tragic loss of the father of the family along the way. But just recently there was some kind of resolution. And so, Paul, really however you'd like to kind of approach this, because there's a lot to it.
Yeah, ultimately what the... God, where do I even start off? It was a 7-year process, and I think it was finalized just within 30 days of the 7-year mark from the initial raid, which started the arrests and the charges and the process and multiple trips to the Court of Appeals and a couple trips to the Supreme Court. And, that whole thing. What it ended up really turning on was the fact that the conspiracy charge, the conspiracy to commit these crimes, to deliver these controlled substances, was a specific intent crime, meaning that the defendants had to specifically have intended to break the law, which we debated about from the beginning and really became the main issue at the end, was if the judge would allow the defendants to testify as to their state of mind. And the prosecution fought and said, no, you can't use mistake of law as an excuse and so on and so forth. And we all knew, again, with the specific intent nature of the crime, that speaking to your state of mind was always going to happen. It was always a possibility. The attorneys always knew that was a big part of the trial preparation. When the prosecution knew they couldn't overcome that hurdle, they had, and the judge granted that ability specifically by denying the prosecutor's motion by saying, no, of course, this is a specific intent crime. You have to talk about state of mind. The prosecutor took that to the Court of Appeals and then tried to take that to the Supreme Court when it was denied at the Court of Appeals. When the Supreme Court refused to hear it, it changed the tenor because now the prosecution knew that these defendants could get up there and testify as to why they were doing what they're doing. Which everybody knew. Ferndale had told them it was okay. The mayor had been there. And we're all fairly familiar with that part of the story. And then towards the end, we were about, maybe we were within a handful of weeks, maybe a month within the original trial date. And the prosecution dropped the charges against the individuals and levied one new charge of the possession with intent to deliver or the delivery of marijuana on the corporation, which hadn't existed in 7 years at this point. The corporation took a plea through its designated agent. It was assessed a fine, and the other cases were closed.
Yes.
So let's set the stage here, though. This all based on a raid in 2010. All this jockeying between Court of Appeals and Supreme Court and everything took place from 2010 all the way up through 2016. Then in 2017, the prosecution realized they were going to get their ass kicked in court and then capitulated by agreeing to some crazy stipulation that only resulted in a misdemeanor to a corporation instead of all the felony drug charges that they intended in 2010 when they originally raided the dispensary.
Just to expand on something that Paul touched on for a second, they went through the proper channels of dealing with the city, got zoned, the proper place. The mayor came in, approval, Craig Covey, who later ran against Sheriff Bouchard for sheriff on a pro-marijuana platform. And then also the county executive, L. Brooks Patterson, was saying specifically on his own website that this should be something that the locals choose how they want to deal with it. So that, in addition,
that was actually right. He had put together it's this infamous 62-page letter that was like one page of saying it's up to you cities how to decide, and here's a bunch of examples from Oakland County cities who had ordinances that went one way or another. When we brought that up in court, they fought us tooth and nail, and all of a sudden that thing disappeared from the website.
Mm-hmm. Yep, they realized it was a tool for criminal defense attorneys and the Oakland County Prosecutor's Department having, dominion and control over everything that happens in stupid Oakland County. Just wave their magic wand and all of a sudden, poof, your help goes away.
Yeah.
Right, because it wasn't just us that they were flying this kite against. They said, okay, well, hey, we can. No cities matter. The county is superior. We'll go through there and challenge it, because in the theory that we had, which is the puzzling part, is that we did have a true entrapment by estoppel defense, because we did have the police officers, the police chief, the police department's consent, and they are the ones who are in charge of interpreting criminal law, and they signed off on it. And that was a successful argument that I had used in other dispensary cases in Oakland County. And that was where Oakland County's attention turned, was to say, doesn't matter if you have municipal approval. It didn't matter if you had anybody else's approval except the police department, because they're in control of the criminal interpretation. Mm-hmm. But that was how they were slicing it very thin, which I think later found out to be, later was proven to be true. But even still, on the fact that they were, you had these motions where it's like, hey, the police chief came through and signed off. I had a dispensary case in Oakland County where my only witness was the police chief, and that's all I intended. And when I told the prosecution that, instead of dismissing the case, he called me about a stipulated set of facts that we could have the judge make a finding on. So even in the point of saying you're completely wrong, I'm going to win my case, instead of being able to concede, they just said, well, how about we find an agreement to where the judge can make the decision, not us.
And speaking of that, Paul, you've been in cases where the attorney general is the prosecutor. I know you have.
Yeah.
And isn't it also true?
Still in one.
Yeah, like when you've gotten the best of them and it's obvious, kind of what direction it's heading, they don't stop. They play it out as long and as hard as they possibly can.
There's a political side to that too, where it's like, okay, so the AG really isn't fighting the case. He's sending good foot soldiers to fight it, and he just, keeps them on that hill until they fight, because he's got all the resources, at his fingertips, even if they're wrong. I've had, even with these current dispensary cases, I've asked AGs to say, okay, well, now that dispensaries are legal, how are we still having a dispensary case? And the answer is typically is something that's above my pay grade, or, hey, I'm just here. I just get paid to show up. They're not thinking functionaries of the system. They're more just responding to what their boss wants to do. But the biggest problem with a lot of these prosecutions, and maybe with prosecutions in general, is that there's a point of being overzealous where you can't back out and look weak. You have to, you can't pull the arrow out. You have to drive the arrow through, and you have to make it look like the process was the reason you won or the reason that there was this victory, not because, I screwed up and I overcharged you or I messed up.
Yeah.
That shows weakness, that shows vulnerability down the road. So if the Oakland County Prosecutor's Office had said, hey, maybe we'll change our stance on dispensaries, or maybe we can't win these cases, it shows weakness, because then it compromises all the other cases they prosecute, and they say, maybe you're being as dumb on this murder case as you are in these dispensary cases. Who knows? So it's a slippery slope for them. Yeah. And a lot of attorneys don't acknowledge the fact that if your prosecutor has a crap case and they're telling you no deals, don't just sit there and take the plea.
I've been victimized by that whole attorney general situation. Our dispensary in Chesterfield Township, we were sued by the township itself, and then the attorney general jumped in on that and joined in the courtroom antics that went down with that, and all of our depositions and all of that shit. So
right, and that was back at the time when they were going to get you one way or another. They were going to come after you, and if they couldn't get you, come in, they'd get you going. And it was more or less because they didn't have a roadmap. They were afraid of what the possibilities were, and no one knew quite how to handle the battle. In perspective, I'm actually glad that, Chesterfield went about it that way rather than dealing with it, in the way Oakland County did.
Yeah, the way they did us in in Oak Park, right? With the guns and the raiding, right?
There was so much cat and mouse going on there too. It was just it's an unnecessary use of resources where it's like, you got this cop sitting out in front of the store waiting to pull over these patients when there's guys doing 90 down 8 Mile, 2 blocks away. It just, none of it made sense at the point.
So,
but
what are we hopeful for as far as decisions perhaps that might be pending from the appellate court or the Supreme Court that might be positive for patients? Do we have any idea what's going on?
What's funny? I'm glad you brought that up. Is I've got a couple cases that are in the appellate courts, Court of Appeals and Supreme Court, that are relatively old at this point. They're 2016, appeals that they were submitted about over a year ago at some point. And they're all more or less with the later interpretations of the Medical Marijuana Act or the additions, some Hartwick and Tuttle issues. And I have one now in the Supreme Court about the retroactivity. And I've been waiting for other cases from the Court of Appeals and the like, and those cases have come out since then. So it seems to me that they're either sitting on a handful of marijuana cases waiting to either consolidate them, to wait for like an ideal case that sets, a whole bunch of standards and makes a bunch of new rules and clears a bunch of other cases off their desk, or depending on what happens after December 15th or through the process, if they make any deference to the Facilities Act to say, okay, all this is now more or less, permissive as an administrative rule, take your remedies up that way. Or maybe those, I don't know. It's hard because the laws that everybody's accused of that we're all appealing are still currently good laws that are still going to be good laws after the passage of all these acts, despite, other than legalization.
Paul, doesn't the court like to clear their docket at the end of the calendar year and start 2017 or 2018 or 2019 fresh?
My impression has always been they like to start every session fresh. So that's why you get the anxiety towards, they're about to take a break, and you'll get a week's worth of opinions all just pushed out because they're about to go on vacation. Yeah. That's typically what I wait for. Or, usually after the case is heard, give it 6 months to 8 months before the opinion comes out. But it just seems that these marijuana cases, they're sitting there. It's like they're sitting on one person's desk waiting for that one person to do, something fairly broad with all of it. And that's like I said, I'm waiting for a case that's either a general case that's one big rule, or them denying them all and saying, but I go back to it. If they would have denied these cases, if we were waiting for what had happened to a lot of the prosecution motions in the clinical release case, was they just said, we're not going to hear it, those opinions come out in months. And if the cases, these marijuana cases that are currently pending, if that were the case, they're going to say, hey, we're not going to hear it, go forward. I want to believe we would have heard that by now. I'm not going to wait a year just for them to say, oh, we're not going to hear it.
That's awesome.
Especially with cases that have trial dates set or, where it had to be stayed pending the outcome.
So, Paul, who would be this one person who we're talking about, this mythical individual who may have all of this sitting on their desk? Is that the appellate court chief justice who dictates who gets what case, or where would that be?
You know what? If there is that, if that one inbox does exist with all these files on it, I would think that it is somewhere up there with one of the more experienced clerks, because, and perhaps at the direction to say, okay, well, we're taking these cases and we're doing this, and sit down and find the similarities, find the commonalities, and perhaps see if there are, 4 or 5 cases that have like a general rule to be extracted from it. And I see this with gun cases. You'll get, 2 or 3 defendants consolidated, and they'll have 2 or 3 issues and, obviously different set of circumstances. But then the rules they come out with create sort of one comprehensive rule. That's where, just from the passage of time, that's where my thinking is. They're trying to come up with, like, not to say like a Hartwick-Tuttle type of reasoning, or consolidation where they explore all the issues and give you one good roadmap, but maybe Hartwick and Tuttle is the best example we have of, consolidate some cases, get one general rule out of it.
Yeah. So, Paul, I've got a municipal question concerning what's going on in Lansing. I'm going to try to clearly articulate what's going on because it's kind of weird, and then just get your thoughts on it. Now, this does not have to do with the initiative that was denied ballot access. This is a separate issue. That happened, and then the city council passed an ordinance. The people then got enough signatures by referendum to push that to ballot. So the council has the choice to kind of rescind that or let it go to ballot to see if the people want to approve their decision on the ordinance. So if they do just repeal it and take it away, what are their options? I'm hearing things like they have to wait for a year before they can do something else, that maybe they could amend an existing one. Their existing one, of course, has to do with the Michigan Medical Marijuana Act and not opting into the MMFLA, but maybe they can amend it enough to get there. What's your opinion on what the options would be if they decide to pull it away?
If they have to rescind that ordinance, it doesn't strike me, and I'd have to explore it, but it doesn't strike me that they couldn't make a ruling on that issue, within, if they're talking about this 1-year ban. It seems to me that they would have to then revisit the language of the ordinance itself, and I guess maybe try to compare it up against what the objections are. My fear is that depending on how or what makes the ballot, the ballot will propose a yes or no question, and depending on what that yes or no question is, it's going to be confusing as hell. Because if the council says, okay, fine, we're not going to rescind, we're going to put our proposal or our ordinance up on the ballot, and if the people want to say yes or no, then great. So that is a positive. You say yes, you want to opt in. Whereas if they say, we're not going to rescind it, we're going to do nothing, and you can put your vote, we're going to actually pass our ordinance, we're going to put your vote up as in the opposition on the ballot, and if they vote in opposition, it's going to be, do you oppose the passage of the ordinance, or do you oppose the placement of these facilities as written by it? And you vote yes, then that's the negative vote, so you're opposing it. So it could get tricky for the voter to say, what does this language mean? if we have an ordinance, am I voting against it, or am I voting on the ordinance as already passed? And in terms of when this could be on when this would be on the ballot, it would be, depending on the deadline, on the next available election time, which would
Spring.
be November.
Oh, November. No, it's probably too close to November for it to still make it to
That's
November.
what I'm saying. If it's cut off now, then we have an election in the spring. Who the hell votes in the springtime?
Old people.
Yep.
Right.
Well, so the issue of how it gets is less to me right now less important than does this now stop everything, or can the city council do something?
I think the city council can do things, because the other one is that they're saying we can't pass this FLA ordinance because of a technicality. We can't introduce another ordinance, but the city wants to take advantage of it. Then they can go back and amend the existing MMA ordinance, which may not be good for people who use it, but it's better than nothing. But it's also, I don't know, that's politically dicey, because that's a backdoor. Mm-hmm. You're going to say, oh, fine, we're not going to do the FLA this way, we're going to go backdoor the FLA. Those meetings are going to become more problematic. It's going to be more of a there's going to be more political backlash. I mean, these aren't, that's the problem with city council in these positions, is these aren't brave political positions. These aren't people who say, okay, well, I can, go against half the voters. These are people who say, hey, I depend on, my job is to give the voters what they want. And a lot of them, if they hear any real vocal pushback, they'll take that as a no, despite all of the approval that they're hearing otherwise.
Right.
That's the hard part. I mean, God, if they have enough signatures to get the opposition on the ballot, I think Lansing's smart move is to let that happen. Because they might not, if it passes and there's an ordinance and they suspend the ordinance pending the results of the election, I don't know. It's a very odd position. It's a very odd position.
It's strange. I think the intent of the signature gatherers in this case was good. It was noble. It was like, this is too restrictive. This is not what we were asking for. You can't just ram this down our throats. Mm-hmm. But now that there's a situation where nothing may happen for a little while as a result of it, but that may be okay for a lot of people.
Well, and that might be, if that's the intent, to say, hey, look, we want it less restrictive. I guess the question of when, because there's two theories on stuff like this: is, do you fix the car while it's in motion? Are you essentially building the plane while you're flying it and fixing it while you're flying it, or are you the idealist to say this must be perfect before it takes off?
Yeah, because they could have let this pass and then just worked on a subsequent measure for a few months from now and fix some of those things.
Sure,
potentially.
And I tell you what, politically, it's easier to make the amendments because you're starting at a point of agreement. You're saying, hey, we agree with the Facilities Licensing Act. We agree that there should be dispensaries. Okay, now let's talk about how. Yeah. So you're not starting with a disagreement. You're starting with the fact that you are agreeing on the same side. So if you have, if these are pro-facilities people who are anti-ordinance, sometimes it's, and marijuana community is terrible at this, recognizing an enemy versus an imperfect friend.
Incremental increase, not perfect, but we gain some ground here.
Correct.
Where we could just let it not get any, so it's always that balance.
Right. Correct, and it's the same way as like, okay, build a house or remodel a house. They want to build a house, they want it perfect. Well, that's a longer process. Buy a house, put some paint on it, make it the way you like it. Nothing is perfect. Politics is give and take. Politics is the worst compromise of your life. So that's the trouble, is that the people who are, let's say, pro-marijuana but anti-ordinance, they'll have nothing instead of something. And if perhaps that's what they want. Who knows?
Yep, it's a tough call. I mean, I'm an idealist of sorts when it comes to this issue, and it's taken me a long time to realize, that you have to take some ground when it's given to you. And I feel for the people who are trying to hit the home run a little bit, because that's kind of how I feel too. But I have recognized it doesn't quite work like that, and you're not functional if that's your approach.
No, and I tell you what, this is the analogy that unfortunately hits home, is that politics is like finding pot on vacation. right? You don't care at some points what it is. I got a bag of weed. The people who are just like, I got nothing. I have no options. It's not legal here. I'm in the middle of nowhere. And, beggars can't be choosers when it comes to it.
Right.
They're holding off. It's like, you want to smoke a joint of swag or smoke nothing? Well, it's like, okay, well, what kind of guy are you? What are you what are you made of? If you're really holding out for that and you're a purist, then you will suffer until you get to your goal. If you are looking to get things accomplished, then you can maybe perhaps make more with the very little they give you, as long as you're willing to participate.
I would smoke the joint of shitty weed, just for the record.
Fuck yeah, all day. Give me 2 of them.
Yeah.
I would have smuggled
because
some
it gets you closer to your goal.
Yep, I agree.
That's
terrible, because we can't agree that, like, yes, we should start by saying yes, we want facilities in our cities. Get the police power ordinance passed that says we want them. Now let's fight over zoning.
So when are you running for mayor of a city there, Paul? We need to wrap it up, but I just want to know. We got to get you in public office, bud.
Talenda 2020. Look for it somewhere.
Right.
Now more than ever.
Better than Jeff Feiger 2020, which I've been seeing on my television. You should have his ad budget, Paul. Listen, Paul, thanks very much for joining us here on the Jazz
thanks,
Cabbage
guys. I appreciate
Cafe.
it.
We'll have you in studio one of these times too, man.
Yeah. Give me a shout. Look forward to it.
Thanks a lot.
Wonderful.
Thanks. Take care.
Attorney Paul Tylenda.